Just to introduce Lindsey and me. Lindsey has came to Farrar with a very, very distinguished academic career that had taken her to Liverpool, Manchester, and Lancaster. And she's been in Farrar now about 3 years, doing primarily personal injury work, particularly industrial disease, silicosis, deafness, and building a very, very successful practice. I've been in Farrar a few more years than that, probably about 10 now. My work is exclusively either personal injury or clinical negligence, probably splitting to about 70-30, 60-40, something of that type. The inspiration for the talk that we're going to give today was a recent case of Holmes in which Rob Harrison, who sits in Cardiff, was appealed, and Lindsey had looked at that case and indeed had written a very interesting article on that on our website. So that was the start of, we were looking at webinar topics, and we thought that material contribution would be a good webinar topic to begin with. But when you start to look at things, you realize that you can't really look at material contribution in isolation, and you have to look at it as part of the overall causation concept. And even as experienced practitioners, when you go back and look at those and look at the way that the court has evolved in the last 20, 25 years, there's so much you learn, and it really does perhaps assist us. And hopefully, if it assists us, it also assists you. So what started as a reasonably niche topic to discuss has sort of expanded to become something that we might struggle a little bit to deal with in the time available. Just very briefly in terms of what we hope to achieve, there's a Q&A button that you can press that obviously people have already dealt with by indicating that they can hear me. If you want to send a question as we go, please do. We'll try and get to questions at the end. We'll try and have a situation where people can ask questions live. The other obvious thing is if you do go through the talk and you decide there's something that you want to ask, please feel free to email either Lindsey or I, and we'll do our best to help with any question that you may have. Can't guarantee to know the answer, but we can certainly try and look at it. Just in terms of the slides as well, the slides are fairly full. Copies of that will be available. I think that Kelly records the webinar itself, which can be made available. But I suspect more likely, if you want copies of the slides, again, email either of us or Kelly at Farrar's, and those can be made available pretty easily. Just as the agenda, you can see, I'm not going to take you through all of that, but you can see what I was trying to say from the outset, which what started as a niche discussion has expanded into a more general assessment of causation where everything fits together. And it's having that sort of framework that's probably quite helpful in terms of understanding where different parts of it come together and different cases collide. By the end of it, you'll get the impression that there's a lot of conflicting information in relation to particularly scientific causation, industrial disease, material contribution particularly is very poorly understood really, and not just by us as practitioners, but by the judiciary when they get to address it. So hopefully just understanding where everything fits together will be helpful, and we can give a little bit of background. So I'm going to hand over to Lindsey to start with factual causation.
Thank you, Andrew. So factual causation is concerned with establishing the necessary connection between the defendant's wrong and the claimant's damage. And difficult questions requiring scientific evidence of cause and effect can arise in relation to factual causation. And this issue will usually depend heavily upon expert evidence. In some situations, the crucial question may be whether a factor that the defendant's wrong exposed the claimant to is capable of causing the effect the claimant has identified as damaged. And without a sufficient basis for believing that the factor can cause such an effect, the court will have no basis for concluding that it caused the damage in the specific case. Sometimes, however, the evidence only goes so far, and it goes no further than establishing that a factor has materially increased the risk of the claimant suffering that particular harm. In other situations, the crucial question may well be whether there is sufficient evidence to support the inference that the factor played a role in causing the claimant's damage, rather than that the damage being wholly attributable to some different factor or factors. And sometimes such disputes can be resolved in the claimant's favour on the basis of a finding that the defendant's wrong made a material contribution to the damage, even where it's acknowledged that the contribution was not the sole or even the main cause of harm. Moving then on to legal causation. Now, cases involving multiple causes where the damage sustained by the claimant is the product of a number of events, only one of which is in fact the defendant's wrongful conduct, can give rise to particular problems. And in these cases, the court is faced with a choice as to whether the defendant's wrong should be treated as the operative or effective cause of the loss for the purposes of attributing legal responsibility. So, for example, where there have been two acts of negligence, say by the defendant causing first personal injury to the claimant and then the subsequent medical treatment received by the claimant, it's not necessarily obvious that the second act of negligence excuses the defendant from responsibility for the ultimate consequence. And in these cases, typically, there's no dispute or uncertainty as to what in fact happened to cause the claimant's damage. Rather, the question is whether the event for which the defendant is responsible will be treated as a cause for the purposes of attributing legal responsibility. And the court clearly has to exercise a choice to make an evaluative judgment as to whether the defendant's wrongful conduct constituted a legal cause of the damage, hence causation in law. Looking then at the but-for test. Now, the first step in establishing causation is to eliminate the irrelevant factors. And this is the purpose of the but-for test. So as you can see on the slide, the test asks, would the damage of which the claimant complains have occurred but for the negligence or other wrongdoing of the defendant? And if the damage would have occurred in any event, then the defendant's conduct is not a but-for cause. And the key case in this aspect is the Barnet and Chelsea and Kensington Hospital Management Committee. And in this case, the claimant's husband was sent home from hospital after complaining of acute stomach pains and sickness. He died later that day of arsenic poisoning. Now, in this case, the hospital admitted negligence in failing to treat the man promptly. But the widow's claim under the Fatal Accident Act failed because it was established that even if he had been treated promptly, he would still have died from the arsenic poisoning. So therefore, there was no causal link between the defendant's negligence and the patient's death. The but-for test functions effectively as an exclusionary test, i.e. its purpose is to exclude from consideration irrelevant factors. And the fact that the defendant's conduct is found to be a cause, applying the but-for test is not conclusive as to whether he should be held responsible in law, since the function of the causal inquiry in law is to determine which causes have, and this is the keyword, significance for the purpose of attributing legal responsibility. Moving back over to Andrew.
So hypothetical conduct, you often have a situation where there's a failure by a defendant to do something that amounts to a breach of duty. The court then has to look at, well, what would have happened had that breach of duty not taken place? So a pretty obvious example is Williams, where a steel worker was working at height, fell 70 feet to his death. The defendants were in breach of duty, breach of statutory duty, in failing to provide him with a safety harness. So as a matter of the immediate common sense, you'd think that failure was causative of the injury that the claimant suffered and obviously his death. However, evidence established that the dead man hardly, if ever, wore a safety harness, even when one was provided. and the widow's claim failed on the balance of probability. He wouldn't have worn a safety harness even if it was provided, and therefore the failure to provide a safety harness was not causative as his death. So it indicates that the court has to take a practical, common sense approach to it to try and infer as to what might have happened if the breach of duty hadn't taken place. It's right to say that that's a case back in the 60s when perhaps approaches to health and safety are a little bit different now. The court would certainly need pretty strong persuasion to conclude that a claimant these days wouldn't have worn something. But it remains the test that if the evidence establishes that, then for obvious reasons, they don't make out their claim. Now, consent as under clinical negligence claims, just to go on to the next slide. A claimant, obviously, who alleges that a doctor has negligently failed to advise them about the risks of a particular procedure must then prove that had they been informed of those risks, they wouldn't have had the treatment and they would have avoided the risk that then materialized. Again, that makes perfect common sense. But of course, in consent cases, the evidence is inevitably clouded by what's happened. As a doctor mate of mine said to me many years ago, when the consent laws were being redrafted as a result of Montgomery, nobody ever complains about lack of consent in a surgical procedure that didn't go wrong. It's only when it goes wrong that with hindsight, we have to look at it and say, well, what would the claimant have done had they been warned of the risks? But the fact is that the claimant needs to establish that had they been told about the risk, they would have made a different decision. And the court gets used to evaluating that type of evidence in the light of the fact that what the claimant would have known at that time, what their concerns were, what their agenda was in terms of treatment and the like. And that's a very, very familiar concept that we come across. Now, Chester is an extremely unusual case because it's an exception to the but-for rules on causation. So what happened in Chester is that the claimant was not informed of a 1 to 2% risk of cauda equina syndrome occurring as a result of back surgery, even if the back surgery wasn't undertaken negligently. So needless to say, the operation took place, the risk then eventuated. And the evidence that the claimant gave was this. Well, she couldn't say that she would not have had the surgical procedure. It was something that she was very keen to have for treatment purposes. But what she did say is that she would not have had the surgery at the time that she had it. She would have wanted a period of time to consider the risks of CES and to consider whether she wished to proceed with the surgical process. So she wouldn't have had surgery on the day that she did have it. And obviously, what she then said is because that risk is only a 1 to 2% risk of it occurring, on the balance of probability, if she'd had surgery on another day, it wouldn't have eventuated and she wouldn't have suffered her injury. Now, that went all the way to the House of Lords as it then was, and they accepted that that was the correct approach. They accepted that this operated for policy reasons as an extension of the but-for test. But I had a situation a couple of years ago, an unusual situation where a claimant had had an operation cancelled by the NHS, and she alleged that there was a breach of duty that flowed from that in fact, they cancelled it negligently. The consequence of not having her operation when the NHS should have provided it is she went privately. So she had the operation on a different date, in fact, a sooner date than she would have had it with the NHS. The scalpel broke in the course of the operation. That was a very, very rare risk, but a risk that's always there. It wasn't related to negligence or the like. And she brought a claim against the trust on the basis that had they not been negligent, she wouldn't have had a private operation on the day that she did. And on the balance of probability, the scalpel wouldn't have broken and she wouldn't have sustained the injury that she did. And that was dismissed. We managed to get that struck out at a preliminary hearing on the basis that the Chester exception, which is what the claimant was relying on, only applies to cases of consent. Otherwise, one's in the situation where it's the flap of a butterfly's wing, in the sense that, well, she might have had it on a different day, but we don't know what would have happened and we can't investigate what would have happened. It's entirely hypothetical. Next slide. What would the defendant have done? Many cases are looked at on the basis that a defendant hasn't done something that it should have done. So the question then comes to, well, what would the defendant have done? Belay, though, illustrates that very usefully. It's a claimant in hospital who suffered brain damage as a result of a cardiac arrest, which was caused by an obstruction of her bronchial air passages. The negligence was a doctor should have attended the claimant. A doctor didn't attend it, and that breach of duty was either admitted or established. But things got complicated because what the doctor said is even if they had attended, they would not have intubated. They would have made a decision not to intubate. And it was only the intubation that would have prevented the brain damage that the claimant sustained. So there were two questions for the court to decide. The first question is, well, what factually would the doctor have done? And that, of course, depends upon the evidence that the doctor gives. So if the doctor had given evidence to say, well, had I been there, I would have intubated, then the case is resolved at that first stage. If, in fact, they gave evidence that they wouldn't have intubated, then the court then has to consider whether that is a reasonable response, whether that is Bolam compliant. So the Bolam part of the test has no relevance as to the first part, which is a pure question of fact, but it's central to the second question. And the reason for that is you cannot have a situation where a defendant says, well, we didn't do something, but it wouldn't have made any difference because had we done something, we would have done it negligently. So consecutive negligent conduct is no defense. So you have that two-stage test. What would the doctor have done? If they say they wouldn't have interfered, is the non-interference Bolam compliant, i.e. is there a reasonable body of medical practitioners who would support that conclusion? If there isn't, and it's non-Bolam compliant, then the claimant establishes causation. Going on to the next slide, that's a situation where the question is, what would the third party have done? So Goldsmith was a case where the defendant negligently failed to refer the claimant to a specialist vascular unit. Now, surgery at that vascular unit would have saved the claimant's fingers, which were ultimately lost, and the only way that they could have been saved was through the surgery. Now, there was no direct evidence before the court as to what specialist unit the claimant would have been referred to, and obviously no direct evidence as to what a specialist surgeon at that unit would have done. The trial judge accepted the claimant's evidence that most units would have operated, but he dismissed the claim because a significant minority, would not have operated, and this would have been Bolam compliant. So there was a reasonable body of surgeons who wouldn't have operated, and therefore it was said that the claimant couldn't establish both aspects of the test. Now, the majority of the Court of Appeal said that this was not the right approach. It was sufficient that a majority of the units would have operated because that demonstrated on the balance of probability that the claimant would have had surgery, and that is likely to have resolved the question. And because of that, it was not necessary to move on to the second question as to whether the decision to operate or not would have been Bolam compliant. But of course, that would be very, very different had the defendant led with evidence, which is to say the claimant would have been sent to a particular unit, that particular unit would not have operated, and that decision not to operate would be Bolam compliant, because if they established all of those factors, then of course the claimant doesn't establish causation. So next slide. You can probably gather that Lindsey's been given charge of the slides. They don't allow me to do important things like that. The science bit, scientific uncertainty. Now, there are two stages that Lindsey's already referred to in relation to issues where causation of disease is established either by exposure to a toxic agent or a chemical agent such as a drug or the like. The first and perhaps obvious stage is that it has to be demonstrated scientifically that the toxic agent can cause the disease of which an individual complains. So if you have a situation where somebody's had penicillin and they subsequently develop respiratory problems, if all the evidence is that penicillin cannot cause respiratory problems, the claim goes no further because the claimant can't satisfy the court that the toxic agent has the consequence of which they complain. That, again, perhaps makes perfect and obvious sense. But the second stage of the test becomes a bit more difficult, because what the claimant needs to prove is not only that such an event can be caused, but in the particular circumstances of their case, it was caused. And that's where the greatest difficulties in this case, these cases come, is an individual proving a statistical background, but applying it to them. Now, the obvious example that's used in all the textbooks is smoking. We all know that smoking increases very significantly the risk of lung cancer, and statistically across the nation, there's no challenge to that. But if you have an individual with lung cancer, that might be caused by smoking, it might be caused by background factors, it might be caused by genetic factors. And so the statistics don't demonstrate that that particular claimant has suffered lung cancer as a result of smoking. That just illustrates the difference between the statistics and the individual case that somebody brings. So if we look at next slide, lies, damn lies, and statistics. I learned something with this talk. It's a phrase we often use: lies, damn lies, and statistics. I didn't know it was Mark Twain. So that's something that I've learned. I'm sure most of the people knew that already, but there you go. But Wardlaw is the case that's on the slide. That's an interesting case, because what was argued in that case, it was a delay by the GP in referring the claimant to hospital. And the claimant had been diagnosed with a pulmonary embolus, and the evidence was that 85% of patients who are diagnosed with a pulmonary embolus survive. And the court's, what was then said on behalf of the claimant is that the court should look at the balance of probabilities at the point that that referral should be made, and almost on the basis of the statistics alone, that demonstrated on a balance of probability, had the claimant been referred in time, she would have responded to treatment and then recovered. Lord Justice Brooke, there was that lovely phrase that's in the slide. So it said, he did not understand the argument. If anyone's ever been in front of the Court of Appeal and one of the exceptionally bright judges that you get turns to you and said, I don't understand your argument, you know you're in difficulty. But what Lord Justice Brooke said is this: the court has to consider all of the circumstances as they apply to an individual. Now, what happened to the claimant is that when she arrived at hospital, albeit late, she wasn't responding to the anticoagulant medication that was being provided. And therefore, the court was entitled to conclude that she was one of those persons who fell into the category of the 15% who did not survive despite treatment for reasons that are not well understood by medical science. So the fact that statistically 85% of people recover didn't change the analysis, which has to be of that particular claimant. The fact that her chemical reaction when she was ultimately treated showed no improvement, demonstrated that she probably fell into the 15%. This is something that often presents in cancer cases, because you have a situation where oncologists will often say it is the aggressive nature of a particular cancer which determines its outcome. So even though statistically you might have a situation where earlier treatment might across the board demonstrate a greater survival rate, looking at a particular individual, if their reaction to particular treatments is adverse and they don't recover in line with perhaps the way that the clinicians might expect, then that might demonstrate that they fall into the unfortunate category of people who are going to have a fatal disease and a more serious disease than statistically it would demonstrate. Next slide. So Wardlaw is on the medical evidence available. It was the reasonable conclusion to draw. The court should be careful perhaps not to take the logic too far. So for example, you may have a situation where 80% of patients survive with prompt treatment, but 20% die even with prompt treatment. The fact that a patient then dies after delayed treatment does not establish that they fell into that 20%, because of course we don't know what would have happened had they had the treatment at the appropriate stage. So again, it just illustrates that statistics are a factor in the assessment that the court has to make, but it has to be personalized. It has to be looked at as part of the overall picture. Okay, indivisible disease. I'm going to hand you back over to Lindsey.
Yes, moving on to indivisible disease, Andrew will cover later divisible disease. As already identified, the claimant doesn't have to prove that the defendant's breach of duty was the sole or even the main cause, provided that they can demonstrate that it materially contributed to it. And the key case in this is the one up on the slide at the moment, Bonington Castings Limited and Wardlaw. And this is where the claimant contracted a disease from inhaling air which contained silica dust at his workplace. And the main source of the dust was from pneumatic hammers for which the employers were not in breach of duty, the innocent dust. Some of the dust, effectively known as the guilty dust, came from swing grinders for which they were responsible by failing to maintain the dust extraction equipment. But there was no evidence as to the proportions of the innocent dust and the guilty dust inhaled by the claimant. And indeed, such evidence as there was indicated that in fact there was a greater proportion came from in fact the innocent source. Now on the evidence, the claimant couldn't prove but for causation, in the sense that it was more probable that not that he had the dust extraction equipment worked efficiently, he would not have contracted the disease. But nonetheless, the House of Lords at the time drew an inference of fact that the guilty dust was a contributory cause, holding the employers liable for, in fact, the full extent of the loss. And the claimant didn't have to prove that the guilty dust was the sole or even the most substantial cause if he could show that on the balance of probabilities, the burden of proof remaining with the claimant, that the guilty dust had materially contributed to the disease. Anything which did not fall within the guilty dust, anything that did not fall within the principle de minimis non curat lex would constitute a material contribution. Now, Bonington's and Castings is significant because it was in fact an express departure from the normal requirements to prove but for causation. Now, Lord Reed's description of the evidence is important, and the quote's up on the slides. And the medical evidence was that the disease that the claimant suffered from was caused by a gradual accumulation in the lungs of minute particles of silica inhaled over a period of years. That means, I think, that the disease is caused by the whole of the noxious material inhaled, and if that material comes from two sources, it cannot be wholly attributed to material from one source to the other. Now, the latest case in relation to indivisible disease, already referenced by Andrew in the introduction, is the case of Holmes. Now, in the case of Holmes, the Court of Appeal was required to review the development of the law relating to causation and indivisible disease since Bonington, noting that Bonington was, as you can see from that citation, 1956. And significantly, it held that the principles established in Bonington of material contribution should apply to indivisible diseases as well. However, on these particular facts in relation to Holmes, the court found that there was insufficient evidence that the defendant's tortious exposure of the claimant to the substance had caused or materially contributed to his disease. Now, just providing a bit of background to Holmes. The claimant was employed by the defendant from 1982 to 2020 and claimed for damages from the defendant because of its breach of common law and statutory duty in the period from 1982 to 1997, so not the full period of their employment. And it was the claimant's case that he'd been exposed to unsafe levels of TCE, which is an organic solvent. And the claimant was diagnosed with Parkinson's disease in 2014. Now, Parkinson's disease is an indivisible condition. The Court of Appeal in Holmes, quite helpfully at paragraph 31, set out the definitions of divisible and indivisible diseases. And it stated that it is a characteristic of divisible diseases that once initiated, their severity will be influenced by the total amount of the agent that has caused the disease. By contrast, once an indivisible disease is contracted, its severity will not be influenced by the total amount of the agent that caused it. Now, as a matter of basic principle, a claimant is entitled to recover the damages, as we've already said, either caused or materially contributed by the defendant's negligence. Now, the first issue that the Court of Appeal was required to address was whether the judge in the lower court had adopted the wrong test in law for proving causation, namely that it was sufficient in an indivisible injury case to demonstrate a material contribution to injury, regardless of whether, but for the tort, the injury would have occurred in any event, material contribution and the but-for test. Now, at paragraph 30, Lord Justice Stuart Smith stated that this ground of appeal raises complex and difficult questions of law in an area that has been bedeviled by apparent inconsistency and imprecision at the highest level on multiple occasions. And Lord Justice Stuart Smith, in fact, comprehensively reviewed all the authorities in relation to this particular issue, and held at paragraph 60, as already alluded to, that the Bonington principle of material contribution should apply to indivisible diseases. He then set out two facets of a court's determination of causation in such cases. Now, these are generic causation and individual causation. Now, dealing first with generic causation, in this case, this was the question of whether exposure to TCE can cause or materially contribute to the causing of Parkinson's disease, the mechanism of interest being the destruction of the patient's dopaminergic neurons, and this is alluded to at paragraph 96 of that judgment. Now, they held that although TCE has long been identified as a compound of interest, the evidence to prove generic causation is lacking whether one is applying the legal or a scientific standard of proof. And it held the evidence did not justify, in this case, a finding of generic causation. Now, looking at the 6 points listed on the slides. So first, legal issues of causation have to be decided on the basis of current knowledge. Proof of causation for the purposes of legal liability is different from scientific proof. Thirdly, the generic causation question should be precisely put and evidence needed to weigh on that precise question. In this case, the fact TCE may have been toxic in other ways was not in fact informative. Fourthly, even though it was found that this was a material contribution case, it is of note that at the level of generic causation injury, there seemed to be some reliance on what's referred to as the odds ratio relative risk, which is determined by one epidemiological study, and it fell well short of evidencing a causal association. Also of note was the observation at paragraph 105, which refers to the 5th point on the slide, which is the Bradford Hill criteria. And it stated that neither of the expert epidemiologists thought the application of this Bradford Hill criteria, in fact, provided an answer. The judge concluded that strict application of the criteria to the facts of the present case didn't really take the case much further under those circumstances. And whilst rodent studies suggested a plausible causal mechanism for TCE causing Parkinson's, it was not possible to extrapolate from the same in order to confirm the impact on humans to the legal or scientific standard of proof. Now, in relation to individual causation, given the negative finding on generic causation within Holmes, it would be necessary for the claimant, in order to advance his case on this limb, to show features of his case that are not reflected in the generic evidence that compel a finding of causation, such as a relevant and repeated response to challenge and re-challenge by exposure to TCE. The Court of Appeal held in Holmes at paragraph 119 that although it was established that exposure to TCE is a risk factor for the Parkinson's disease, the judge's finding that tortious exposure to TCE caused or materially contributed to Mrs. Holmes' disease was not sustainable on the evidence and was in fact wrong. And Lord Justice Stuart Smith confirms at paragraph 63 in relation to Bailey and MOD that we are bound in the light of Bailey to find that the Bonington material contribution principle applies to cases of indivisible injury, and that where the principle applies, the claimant does not have to show that the injury would have happened but for the tortious exposure for which the defendant is responsible. Therefore, Holmes is key in establishing that Bonington does apply to indivisible injury or disease, apologies, but in this particular case, the claimant didn't make out their case in relation to the requirements in order to be able to establish that. Moving back to Andrew with divisible harm.
If we look at the most obvious form of divisible harm, it's a question of time. Where it's possible to identify the precise extent of the contribution that the defendant's made to the claimant's damage, then the defendant is only liable to that extent. So the obvious example is noise-induced hearing loss. Thompson and Smith's repairers, the claimant suffered progressive hearing loss as a result of industrial noise. Now, the defendant was only liable for the part of that deafness which occurred after the exposure became a breach of duty. Now, typically in deafness cases, that's 1963, but of course there may be all sorts of different considerations in any one particular case. But what the court was saying was that although the claimant's deafness was entirely related to his occupational exposure, the period that predated the breach of duty was to be taken from the damages that the claimant would recover, because you could satisfy, that the court could be satisfied that it was a time and weight exposure in relation to the injury that was suffered, and where the court can make that, draw those conclusions, a claimant will only recover for the injuries that were sustained during the period of breach of duty, or put another way, the defendant is only responsible for injuries that were referable to its particular breach of duty. So far as deafness cases, the other obvious example we have is that people are often exposed to noise outside of work, whether it's hobbies such as shooting or the like. And again, anything which predates the date of knowledge, anything that occurs outside of the occupational environment has to be taken from the overall hearing loss. So you establish what the claimant's hearing loss is, you establish what that sounds in terms of damages, and then there's a pro rata reduction for any other elements that come into the equation. We're not talking about the employment making a material contribution to the deafness overall. You look at it on a time weight basis. Similarly, in Holtby, which is the next slide, claimant was a marine fitter, worked and was exposed to asbestos dust for a period of over 40 years. Half of that period he worked for the defendant, and half of it, or the remainder, he worked for other employers doing very, very similar work in very similar circumstances. Now, he developed asbestosis and he sued the defendant, who were held to have been negligent and in breach of statutory duty. But the judge held that the defendant was only liable for the damage that they had caused. The evidence indicating that if the claimant had been exposed to asbestos whilst working for the defendant, his condition, or if he hadn't been exposed to asbestos from other sources, then his damages would have been noticeable, or his injuries would have been noticeably less severe. So general damage was reduced by 25%. Stopping there, looking at the general picture in relation to Holtby, a deduction of 25% is quite generous to the claimant, because the suggestion perhaps is that half of his time had been spent working for somebody else and half of it had been for the defendant. On a strictly linear analysis of it, looking at time and weight of exposure, a deduction of 25% was quite generous. But the claimant appealed to the Court of Appeal on the basis that the defendant's breach of duty had materially contributed to his damage, that he was entitled to then recover the full extent of the loss, applying Bonington Castings Limited and Wardlaw. Alternatively, he argued that once he had proved that the defendant's conduct made a material contribution to the damage, then the onus was on the defendant to prove that somebody else was responsible for a specific part of the damage. So this is the next slide. And the Court of Appeal rejected both arguments, upholding the judge's deduction of 25%. The onus of proof remained on the claimant to show that the defendant's tortious conduct had made a material contribution to the loss, but strictly speaking, the defendant was only liable to the extent of that contribution. It was a point that was not raised or argued by the defendant in either Bonington Castings or McGee, which we'll come on and look at. But once it is raised by a defendant, the burden of proof is on the claimant to prove how much of the defendant's breach of duty is responsible for the injuries that were suffered. Now, it's easier in cases with asbestosis than in many other industrial diseases, because the evidence is that there's a linear progression of the disease depending on the amount of dust that's inhaled. And so it can be said that essentially all dust has contributed to the final disability, and it's a case of cumulative harm, where, of course, the more you're exposed to, the longer you're exposed to it, it causes greater injury, and therefore you can divide up the injury and establish an apportionment for which a defendant is responsible, the time and weight analysis. So it's not just the time, it also looks at how much asbestos you've been exposed to, but it is it's an exercise that the court is capable of doing, of establishing just how much of the injury suffered by the claimant is attributable to the breach of duty by the defendant. So on to the next slide. This is material contribution to the risk of damage. So McGee was a case back in 1973. The claimant conducted dermatitis as a result of the presence of brick dust on sweaty skin. Now, some exposure to brick dust was an inevitable result of working in the brick kilns and wasn't a breach of duty. However, the defendant's negligence was failing to provide washing facilities at the site, so that the claimant had to cycle home covered with abrasive brick dust. And it wasn't possible to prove whether it was the guilty brick dust that he had on his journey home, essentially, or the innocent brick dust that couldn't be avoided in the course of his employment that had triggered the dermatitis. At best, it could be said that the failure to provide the washing facilities had materially increased the risk of dermatitis. Now, the House of Lords held that the defendant was liable on the basis it was for the claimant to show that the defendant's breach of duty had made the risk of injury more probable, even though it was uncertain whether it had been the actual or sole cause. So it essentially drew a fictional inference to get round the but-for test on the basis that there had been this material contribution to the risk of suffering injury. That then is different, the next slide, from the situation in Wiltshire. And the conflict between these two cases is quite a major part of the academic discussions on this area of law. So Wiltshire was a case where the infant claimant was a premature baby. He received excess oxygen as a result of negligence from junior doctors. He developed RLF, which was a blindness. Or it was a neurological condition that caused his blindness. Now, there were 5 discrete possible causes of this, and any one of those might have caused his injury, but only one, the excess oxygen, was a breach of duty. So there were 4 potential innocent causes of the RLF. Now, the trial judge relied on Lord Wilberforce's judgment in McGee and held it was for the defendant to prove that the claimant's condition did not result from the excess oxygen, so essentially reversing the burden of proof. The majority of the Court of Appeal agreed, suggesting that D had caused the injury, even though the extent and the existence of the contribution could not be scientifically ascertained. Now, the House of Lords then disagreed, relying very heavily on the dissenting judgment of Sir Nicholas Brown Wilkinson, who observed that a failure to take preventative measures against 1 out of 5 possible causes is no evidence as to which of those 5 caused the injury. So the distinction is in McGee, brick dust caused the dermatitis. The longer the abrasive brick dust adhered to the skin, the more likely it was that dermatitis would develop, which of course is what happened. In Wiltshire, it was not proved that excess oxygen, rather than some other innocent agent, one of the other 4 causes, had actually caused or contributed to the claimant's RLF. Nor had it been demonstrated that the excess oxygen made the other innocent causes more likely to eventuate. So you're in a situation where it's not possible simply to use McGee just to infer that of the 5 explanations, the guilty explanation was a causative factor. The effect of Wiltshire was that the defendant's breach of duty increases an existing. So the effect of Wiltshire was where there's evidence that the defendant's breach of duty increases an existing and causative risk factor. And that's the important distinction. The court might then choose to take a robust and pragmatic view of the evidence and infer that there's been some material contribution. However, if the defendant's breach of duty merely adds a new discrete risk factor to existing innocent risk factors, it's not legitimate to then infer that it is the guilty risk factor which probably caused the damage. And that proposition still holds true after Fairchild, which we'll look at in a moment. But just over to Lindsey now, just to look at cancer.
Looking at the case of Novartis Grimsby that's up on the screen, in this case, the claimant developed cancer of the bladder, which is a non-divisible form of damage. He was a smoker, but he was also exposed to a toxic agent at work. And both of these were known as risk factors for bladder cancer. However, the evidence indicated that the risk associated with the toxic agent that he'd been exposed to at work was in fact 70% of the total risk. And the Court of Appeal held that the claimant had established but-for causation because the risk attributable to the occupational exposure to the toxic agent more than doubled the risk associated with smoking. And there was in fact no need to consider whether the negligent exposure materially contributed to the harm or materially contributed to the risk of developing the harm. Now, Lord Justice Smith observed in this case that the natural inference to draw from the finding of fact that the occupational exposure was 70% of the total is that if it had not been for the occupational exposure, the respondent would not have developed bladder cancer. And in terms of risk, if occupational exposure more than doubles the risk due to smoking, it must, as a matter of logic, be probable that the disease was caused by the former. Andrew will then look at multiple tort visas.
Coming back in my very briefly, aware of time, and there's a fair bit to get through. Just in relation to Fitzgerald and Lane, what you need to start with is the claimant's participation in order to get a proper apportionment. What had happened in that case is the claimant was crossing the road. He was struck by a car driven by D1, thrown into the path of D2, and as a result of that suffered tetraplegia. The evidence was unclear as to whether it was the collision with D1 or the collision with D2 which had caused the tetraplegia, so the court had to take a view. Now, the judge held that all three parties had been negligent, that it was impossible to say whether the injury had been sustained as a result of the collision with D1 and D2, and therefore, essentially, responsibility ought to be borne equally by all three. That was then appealed to the Court of Appeal. The Court of Appeal upheld the judge's decision on causation as between the two defendants, but allowed the defendant's appeal in relation to apportionment on the basis that it was the claimant's contributory negligence was a more significant factor, and it was right that that was established first of all. And essentially what they did is to then order that the claimant was 50% responsible for the accident to begin with, but then D1 and D2 were each 50% responsible, bearing in mind that scientifically they couldn't determine which of the collisions had caused the tetraplegia. And that approach was endorsed by the House of Lords, because the reduction of 30% or 33% for the claimant's contributory negligence did not adequately reflect the role that the claimant had played in the accident. So you start with the claimant, and then you may have to look at whether there's some degree of inference to be drawn in relation to what other defendants or the two defendants might have done. Now, we're going to struggle a bit with time with the asbestos wars, so just to summarize it fairly quickly. Fairchild was a case involving exposure to asbestos. We discussed Holtby already, which is a case of asbestosis. Mesothelioma operates in a different way. So the fact is, the more asbestos you are exposed to, the greater the likelihood of you developing mesothelioma. But the cause of mesothelioma is essentially one asbestos fibre, which finds its way into the pleura of the lung and then develops into what is a horrific and fatal cancer. So it is the difficulty that claimants would face in demonstrating that any one of a number of defendants is the cause of the mesothelioma. The reality is it's scientifically impossible. So the matter went to the House of Lords in relation to that, with a situation where the claimant couldn't prove which defendant or when the mesothelioma would have been caused because of the state of science. And the House of Lords overruled the Court of Appeal, established that the claimant and found that the claimant had established causation in the special circumstances of that case, because it was the just result where an individual had been exposed to asbestos as a result of breach of duty. They'd had an injury that essentially only occurs as a result of exposure to asbestos. The fact that they couldn't identify when that took place shouldn't mean that they don't recover. There were 6 conditions that were set out by Lord Bingham. Interestingly, each of the Lord Justices, or certainly 3 or 4 of them, had conditions that they set out as the exception to the but-for, which are known as the Fairchild exceptions, all of which are pretty similar but slightly different. I won't read them out, they're on the slide, but that was what Lord Bingham said. You can see immediately that they're pretty prescriptive and restrictive conditions in order to get around the but-for test. Insurers strike back. That was the case of Barker. So what happened in Fairchild is the claimant recovered entirely for the malignant mesothelioma that they suffered, even though, of course, that may have been as a result of exposure in different ways. But in Barker, what was argued that the claimant, although they established causation with a material contribution, it was a material contribution to the risk of suffering mesothelioma. So all a defendant should be liable for is its part of that risk. So yes, the claimant establishes that the mesothelioma was caused by the exposure with the defendant, but essentially they only recover for the period of time that they work for the defendant in exactly the same way that they would with an asbestosis case. And the House of Lords accepted that, accepting that the Fairchild created an unfairness because in 2 respects. One, it subverts the rule in relation to causation and establishes that the claimant has a lower burden in proving causation. But having done that, it then says that the defendant is responsible for all of the injury, when in fact there may be other tortfeasors involved, and it may be that the claimant is responsible. So Barker put the situation back where a claimant was only entitled to recover for the proportion of the injury that would relate to their breach of duty, and essentially again on a time-weight basis. Following Barker, we then have the Compensation Act 2006. I won't read that out, and bearing in mind that where we are with time, but you can see that essentially the responsible person becomes responsible for the entirety of the injury. They have a right to bring contribution proceedings against another defendant, but that doesn't alter the situation. So a claimant with mesothelioma can sue any defendant who exposed him to asbestos in breach of duty and can recover against that defendant for the entirety of the injury, and it is the defendant then who needs to take proceedings in relation to contribution, which they may or may not do, depending on whether they can identify other employers, whether there's an insurance in place and the like. What does all that mean? It sets it out in the slide. I won't go through that, but you can read that where we are in relation to the evolution of the asbestos wars in the 2000 and beyond, the millennium beyond. Just want to look very quickly then at some material contribution in medical cases. Bailey was a case that was already referred to in Holmes. What happened in that is the claimant underwent a procedure to explore and treat a possible gallstone in the bile duct. Following that, her condition deteriorated significantly. There was a period of negligent care, which then contributed quite significantly to her deteriorating condition. She also developed pancreatitis, although that was not due to negligence, but that caused her overall medical condition to deteriorate. 2 weeks after the original procedure, the claimant aspirated on her own vomit, leading to a cardiac arrest and a hypoxic brain injury. So the causation turned on whether the claimant's inability to respond naturally to the vomiting exercise was because of weakness due to severe pancreatitis and oblique or weakness due to the defendant's negligence. Now, the claimant alleged that as a result of the negligence, she became very much more ill after the first procedure than she otherwise would have been, and that she had to undergo procedures that would otherwise have been avoided. Although she would have developed pancreatitis in any event, that would have been less severe, and the situation, she wouldn't have been so weakened that she would have aspirated and suffered brain injury in the way that she did. The defendant argued that the case was governed by Wiltshire and that adding existing risks to risks that already existed was not proof of which of those risks actually caused the harm. Now, Mr. Justice Foskett held that the physical cause of the claimant's aspiration and her subsequent cardiac arrest was her weakness and her inability to react to the vomit. There were two contributory causes to that, the non-negligent case of the pancreatitis and the negligent cause, which of course was the lack of care and what flowed from that. And since each of those two causes contributed materially to the overall weakness, and since the overall weakness was the cause of the hypoxic brain injury, causation was established. And the Court of Appeal agreed with the judge that the correct test had been applied, and Wiltshire was distinguished on the basis that that was not a case of cumulative and causative causes acting, sorry, that's a tautology, cumulative causative factors operating together. Lord Justice Waller put it very, very well, which is why the quote is there. One cannot draw a distinction between medical negligence cases and others. I would summarize the position in relation to cumulative causes as follows. If the evidence demonstrates on the balance of probability that the injury would have occurred as a result of the non-tortious cause or causes in any event, the claimant will have failed to establish that the tortious cause contributed. So if it would have happened anyway, and the evidence demonstrates that, the claimant doesn't win. If the evidence demonstrates that but for the contribution of the tortious cause, the injury would probably not have occurred, then the claimant establishes causation on the obvious but-for test. But for the negligence, they wouldn't have sustained the injury, then they satisfy the conventional test. But in a case where medical science cannot establish the probability that a but-for act of negligence, the injury would not have happened, but can establish that the contribution of the negligent cause was more than negligible, then the but-for test is modified and the claimant will succeed. This, I think, is where the biggest battlegrounds are going to be in relation to material contribution is in medical cases. Williams and the Bermuda Hospital Board, conscious of time, that was a Privy Council decision where the claimant there'd been a negligent delay in diagnosing and treating the claimant's ruptured appendix. The claimant developed a surgery to remove the appendix. Trial judge held that the claimant had not proved on the balance of probability that the complications were caused by that delay. The Court of Appeal of Bermuda held that the judge had set the bar unattainably high. The defendant's breaches of duty had contributed materially to the complications, and then giving the judgment of the Privy Council, Lord Toulson, said that the parallel of Bonington castings was obvious. It was immaterial whether the cumulative factors operate concurrently or successively. The sepsis from the ruptured appendix had developed incrementally over the period of 6 hours, progressively causing myocardial ischemia. Its development and the effect on the heart and lungs was a single continuous process. The negligent delay amounted to 2 hours and 20 minutes, and therefore, said Lord Toulson, it was correct to infer on the balance of probabilities that the negligence had materially contributed to the overall process, and it therefore materially contributed to the claimant's injury. Popple is a case in 2012 that deals with a CP case. And again, the material contribution in relation to cerebral palsy cases where the window to act is so limited is a major factor, and I suspect that again that will trouble the Court of Appeal in due course. Just going over to, I think, the final slide, or final of my slides, Thorley. Thorley's in there for this reason, that Mr. Justice Sewell held that the authority of the Court of Appeal in B and Hennigan precluded a claim for material contribution in a case involving indivisible harm, although he then said this is evidently a legal issue which is right for authoritative review. Of course, he was right about that, because Holmes then went to the Court of Appeal, and Lindsey has dealt with the facts of Holmes, and that material contribution can apply to cases of indivisible disease. What happened in Thorley, it was a stroke. The claimant had to have an angiogram. As a result of that, the warfarin was stopped either side of that procedure. So it was stopped before the angiogram took place, and then it wasn't restarted until a certain time after. And the allegations that the claimant made, it was stopped too soon, and it wasn't restarted enough. And as a result of the failures in relation to the warfarin, that was what caused the stroke. Mr. Justice Sewell determined that there was a breach of duty, but it was a breach of duty not to start the warfaring for a very short period before it was actually started. And on that basis, it couldn't be said that the failure to prescribe the warfaring for that period made a material contribution to the stroke. Even the claimant's expert wasn't able to say that. Although, of course, Mr. Justice Sewell also said that material contribution didn't apply to indivisible disease, which we know is inconsistent with what was dealt with in Holmes. What's perhaps interesting about it is the way that the court will massage matters to the evidence was that in any event it had not made a material contribution, so that obviously that dealt with the answer as to whether you have to apply a difficult legal concept. I'm just going to go back over to Lindsey now for some brief conclusions.
Yes, just to sum up, McGee and National Coal Board does remain good law. In respect of Wiltshire, again, it's also good law. So where there are innocent possible causes of the claimant's damage and the defendant wrongfully adds another possible cause, the increase in overall risk cannot be equated with a material contribution to the damage. The Fairchild principle cannot assist a claimant who is struggling to show that one factor amongst several factors probably made a difference to the claimant's condition. And where there are multiple tortfeasors and they all add to the risk of damage caused by the same noxious agent, then the principle applies. And following Fairchild, it had been unclear as to whether the principle applied where there were multiple tortfeasors that added to the risk. But Barker and Chorus established that Fairchild could also apply in this situation, provided that the increased risk could be attributed to the same causal mechanism. The case at point 4 confirms that Fairchild will also apply even though other periods of exposure were not attributable to any individual or corporation, but were in fact environmental. And similarly, Barker and Chorus confirms that the principle in Fairchild applies even though a claimant who has developed mesothelioma had also been exposed to asbestos dust during a period of self-employment. And the claimant does not have to establish which dust injured him, and Andrew went through that in depth in the talk. And the exposure to the risk of harm must be not insignificant. The breach of duty must have contributed substantially to the risk that the claimant would contract the disease. It will be recalled that in Bonington, Castings and Wardlaw, the House of Lords held that anything that did not fall within the principle of de minimis non curat lex would constitute a material contribution to the claimant's damage. And it would seem that a similar test is appropriate where the breach of duty contributes to the risk of damage. Andrew has the questions and answer function.
Other than the initial questions as to whether I can be heard, there's no specific questions that anybody has raised.
Thank you.
Let me just flick down. So Neil has asked, worth looking at the Edward Merriweather report and the effects of asbestos on exposure on the lungs, perhaps more of an academic exercise nowadays. I don't know that, the Edward Merriweather report. That would be interesting, Neil. If you could ping me something about that, that certainly would be worth looking at.
Yeah, as you mentioned at the start, Andrew, if anyone does have any questions that they later wish to ask, then either send them through to Kelly or email myself or Andrew directly.
I'm just checking. I think that's everything. Okay, well, as Lindsey quite rightly said, if anybody's got any questions, please feel free to contact us directly. But thank you very much for attending.
Thank you very much.